Will come to order.
All right, you may be seated. State has 35 minutes of its time remaining. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorney. Both sides ready to continue?
Yes, sir. Yes.
Okay. I'm waiting for the crowd to get back in. Okay. All right, let's return to jury.
All right, jury entry.
May be seated. State recognized presence of jury. Defense? Okay, you may proceed with your rebuttal argument.
You'll be happy to know that I have 35 minutes left to talk to you. But I'm hoping to conclude my remarks in about 10 minutes because I want to focus, after a preliminary statement, on what the crux of this case involves, and that is proving the insanity defense. Before I get there, I wanted to make reference to some of the comments that counsel made as it relates to the issue of premeditation. Now, in past experiences, you may have concluded that premeditation involves things such as planning and plotting and stalking, and it does involve those things, but the law is very specific that premeditation does not necessarily involve those things. Premeditation to kill can be formed in an instant. Premeditation is killing after consciously deciding to do so. And that decision, ladies and gentlemen, can be made in the blink of an eye. And I would submit to you that that decision is demonstrated not so much in words, but in this case in action, when an individual, Mr. Rodriguez, slams open, pushes open with force the door to an office building, pulls out a gun, points it, and then diverts attention and fires at another individual. What is that if it is not a conscious intention to kill? What is that if it is not killing after deciding to do so? And once that first shot is fired and he is shooting in the office at other people with a deadly weapon, that conscious intent, killing after consciously deciding to do so, has been formed. This shooting, the shooting described by the witnesses who were there, was not random firing at people left and right in the hallway. If that were the case, he would have been out of bullets at the door. You heard testimony that he took deliberate action inside that office building. Pow, pow. Silence. Walking. Pow, pow. Something catches his field of vision. Pow, 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 pow. All the shell casings around that desk once you get past the first set of cubicles. What is that if it is not consciously attempting to kill other human beings? So with that in mind, you've been here for nearly 2 weeks listening to witnesses, crime scene people, police officers, doctors, a professor, relative, all to come down to one real issue. And I mentioned this, I believe, in my opening statement. And that is, did Jason Rodriguez know it was wrong to kill people? Did Jason Rodriguez know it was wrong to shoot people? Now, you have opinion testimony of doctors who have said at the exact moment of the offense, he didn't know what he was doing was wrong. Keep in mind that the length of time that it took to complete this offense, 4 or 5 minutes or less, you are being asked to accept that for 4 or 5 minutes, Mr. Rodriguez did not know what he was doing was wrong. Speaking of something that doesn't make sense, how does that make sense? How does that make sense? You've even heard the doctors in this case concede that Mr. Rodriguez understood that the law applied to him. He understood, and we've spent a lot of time, maybe more than you would have liked, talking about him taking the gun into the university, him taking the gun into the post office or not, him putting his hands up when the police show up, him getting rid of some of the evidence, him saying, "I'm sorry." Why do we do those things? Why did everyone focus on those particular facts? Because they clearly demonstrate, not just after the crime, but also before the crime. And not 2 years before or 2 years after, but on the day of the crime. Mr. Rodriguez understood that the law applied to him. The doctors agreed. And he even said it. I didn't take that gun onto the school grounds because I know the gun laws. He knew the gun laws. And he followed the law, because to not follow that law would be wrong. I went into a post office. I left the gun in the car because I know the gun law. And to take a gun into a post office, he knew would be wrong. That happened, 15 minutes before he made a beeline for RS&H? So all the way up to 11 o'clock in the morning. He didn't shoot his mother. Let's go back just even a little further. He didn't shoot his mother that morning because he knew it would be wrong. That's the focus of this case. So, counsel, in her closing argument, told you, once you make these findings that Mr. Rodriguez didn't know what he was doing is wrong, we're done here. We've proven this by clear and convincing evidence, and you should find him not guilty. Not guilty by reason of insanity. However, that argument leaves out a critical element or evaluation that needs to take place in this case. And the law here is very narrow, and it's narrow because if somebody is insane at the time of the offense, it absolves them of criminal responsibility. So therefore, it must be narrow. And you must get through that narrow corridor by clear and convincing evidence, not by unsupported opinion. So, doctor, you've given us your opinion about why Mr. Rodriguez you thought he was insane, because he didn't understand what he was doing was wrong. Yes, he knew that if he took the gun and he shot it, that people could get hurt or killed. Okay, we're all past that. We've taken that narrow path together, including that we agree he has mental illness. But here's the question. Doctor, why do you think he didn't know what he was doing was wrong? There could be various reasons a person doesn't know. Well, because of his mental illness. All right? That is part of the very narrow pathway that we have to walk down. What is it about his mental illness that makes you believe or be of the opinion that he didn't know what he was doing was wrong? It's the hallucinations and delusions. Because you have to have those things to have the mental illness in the first place. So, okay. This is where you then need to turn. Mr. Williams, in his preliminary statement to you, talked about the doctors not looking at the facts. And that's on the front end of this. Before they came to their opinion, they didn't look at the facts about what happened in that building. They relied on a summary, which was not as detailed as they would have led you to believe, because it took us hours to present it. And it was complicated, and you had to look at not only the floor plan, but have some understanding of what took place in there. So their work on the front end of this was flawed. And when you look at these instructions, you will see that their work is flawed on the back end too. Because they will take you down that narrow pathway only to a specific point. And it ends with that opinion. Well, he didn't know what he was doing because of his delusions. Well, again, there are very specific considerations that must be made when you are supporting your opinion with the fact that somebody is suffering from hallucinations or delusions. And this is where the second instruction comes in. And I would like to draw your attention to some of the language that we consider, that you will have to consider during your deliberations. All right, here we go. what were Mr. Rodriguez's hallucinations and delusions? The only hallucination that was discussed during any of the testimony had to do with an audio hallucination, that he could hear the voice of somebody that he named Sharptooth. All right. You've heard no testimony that Sharptooth told him that there was danger at RS&H, that Sharptooth told him to do anything, that he was acting under any commands being given by Sharptooth, but that he believed that Sharptooth could communicate with him through various mechanisms involving parts that now get us into what his delusion is. And a delusion is a fixed, false belief. It is a false perception. So what were his delusions? Specifically, that he felt that there was a conspiracy against him, and the purpose of this conspiracy was to ruin him personally, to ruin him financially, to leave him homeless, and that there was a threat of some sort, unspecified, to him and his family. All right, so these are the delusions. So let's look at the language to be considered when you are evaluating delusions as a means that somebody doesn't know right from wrong. Right? We must, or you must, presume that the delusions are actual facts, that they're true, that they exist, that in fact, for our purposes or your purposes, the company, somebody, they, people, were conspiring against Mr. Rodriguez to ruin him financially or to humiliate him, that they were stalking him in this effort. Do those things, if we treat them as true, justify the crime? The language of the instruction is, if the act of the person would have been lawful, had the hallucinations or delusions been the actual facts, the person is not guilty of the crime. So we heard doctor after doctor basically stop on the other instruction, giving us their opinion that because of the delusions, he didn't know the difference between right and wrong. He didn't know what he was doing was wrong, but they did not address this. So just as they were sloppy on the front end, they are now sloppy on the back. Till we got to Dr. Danziger, the last witness. So now we're in a point in the trial where the witnesses can't really go back out and fill in the gaps or clarify matters while testimony is going on. We're at the last witness who admits, I did not utilize this in coming to my conclusion. And if I did, it did not justify the violence. Ladies and gentlemen, we are asking you to complete this path, to look at the evidence that has been presented here in light of this. Was, assuming Mr. Rodriguez's delusions were true, any of them, All of them. Even though he didn't tell the doctors, except for Dr. Olander, that there was any imminent danger at RSNH that day. Did his delusions justify killing anyone? Did his delusions justify shooting anyone? And ladies and gentlemen, once you do the work that their witnesses didn't do, you will find that they haven't met their burden. That they have not established any of this. Because here's where you start. All persons are presumed to be sane. So then, do you have clear, convincing evidence that is precise, explicit, lacking in confusion, that it produces a firm belief without hesitation about the matter in issue? The answer to that is no. Dr. Danziger said. No imminent. Sure, his delusion was that there was the possibility of some sort of danger out there. A tree trimmer was what was told to him. Future danger, possible danger, not imminent danger. And that's why they don't want you to even look at this. This is a difficult case for everybody. We all understand that. And these are not easy issues to have to grapple with, but it's not complicated. It's not that because they claim the defendant was confused that it was so. When you consider the facts that he went in there with a clear purpose in mind, that he executed his plan with cool, calm deliberation, walking in, walking out, taking care of business, eliminating a future threat in his mind. His action is not justified. And he is not insane under the law. And I ask that, as a result, you find him guilty as charged of first-degree murder and 5 counts of attempted first. And we thank you for your attention for the last 2 weeks.
If anyone from the audience would like to leave, now's the time to leave. The doors will be locked as I instruct the jury. Members of the jury, I would like to thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. You will also receive a copy of these instructions. Jason S. Rodriguez, the defendant in this case, has been accused of the crimes of murder in the first degree with a firearm and 5 counts of attempted first-degree murder with a firearm. In this case, Jason S. Rodriguez is accused of murder in the first degree. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Otis Beckford was killed by Jason S. Rodriguez, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree or was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any lawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. In this case, Jason S. Rodriguez is also accused of attempted murder in the first degree. Attempted murder in the first degree includes the lesser crimes of attempted murder in the second degree, attempted voluntary manslaughter, all of which are unlawful, and aggravated battery. An attempted killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find that there was an attempted killing of Gregory Hornbeck in count 2 and or Guy Lugenbill in count 3 and or Edward Sereno in count 4 and or Keandra Harrison in count 5 and or Farrell Hickson in count 6 by Jason S. Rodriguez, you will then consider the circumstances surrounding the attempted killing in deciding if it was attempted first-degree murder or attempted second-degree murder or attempted voluntary manslaughter, or whether the attempted killing was excusable or resulted from justifiable use of deadly force. The attempted killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The attempted killing of a human being is excusable and therefore lawful under any one of the 3 following circumstances. 1. When the attempted killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the attempted killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the attempted killing is committed by accident and misfortune resulting from sudden combat if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. The dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I will now instruct you on the circumstances that must be proved before the defendant may be guilty of murder in the first degree and attempted murder or any lesser included crime. To prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1. Otis Beckford is dead. 2. The death was caused by the criminal act of Jason S. Rodriguez. 3. There was a premeditated killing of Otis Beckford. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Members of the jury, I will be reading the elements of the crimes of attempted first-degree premeditated murder, attempted murder in the second degree, attempted voluntary manslaughter, and aggravated battery, which involve multiple victims. While the names of several victims will be read to you in the order of the counts listed in the indictment, you must remember the following. A separate crime is charged in each count of the indictment. And while they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty by reason of insanity as to one crime must not affect your verdict as to the other crimes charged. To prove the crime of attempted first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1. Jason S. Rodriguez did some act intended to cause the death of Gregory Hornbeck and or Guy Lugenbiel and or Edward Serrano or Keandra Harrison and or Farrell Hickson that went just beyond thinking or talking about it. 2. Jason S. Rodriguez acted with a premeditated design to kill Gregory Hornbeck and or Guy Luginbill and or Edward Serrano and or Keandra Harrison and or Pharaoh Hickson. 3. The act would have resulted in the death of Gregory Hornbeck and or Guy Luginbill and or Edward Serrano and or Keandra Harrison and or Pharaoh Hickson, except that someone prevented Jason S. Rodriguez from killing Gregory Hornbeck and or Guy Luginbill and or Edward Serrano and or Keandra Harrison and or Pharaoh Hickson, or he failed to do so. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. It is not an attempt to commit first-degree premeditated murder if the defendant abandoned the attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose. In considering the evidence, you could consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of murder in the first degree are second-degree murder and manslaughter. The lesser crimes indicated in the definition of attempted murder in the first degree are attempted murder in the second degree, attempted voluntary manslaughter, and aggravated battery. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. Otis Beckford is dead. 2. The death was caused by the criminal act of Jason S. Rodriguez. 3. There was an unlawful killing of Otis Beckford by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done with ill will, hatred, spite, or an evil intent, and 3. is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Otis Beckford is dead. 2. Jason S. Rodriguez intentionally committed an act or acts that caused the death of Otis Beckford, or the death of Otis Beckford was caused by the culpable negligence of Jason S. Rodriguez. The defendant cannot be guilty of manslaughter by committing a merely negligent act or if the killing was either justifiable or excusable homicide. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocations. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, or which caused death. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to the consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act of following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. To prove the crime of attempted second-degree murder, the state must prove the following two elements beyond a reasonable doubt. Jason S. Rodriguez intentionally committed an act which would have resulted in the death of Gregory Hornbeck and or Guy Luginbill or Edward Serrano or Keandra Harrison or Pharaoh Hickson, except that someone prevented Jason S. Rodriguez from killing Gregory Hornbeck and or Guy Luginbill or Edward Serrano and or Keandra Harrison and or Pharaoh Hickson, or he failed to do so. 2. The act was eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act, a series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. It is not an attempt to commit second-degree murder if the defendant abandoned the attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose. To prove the crime of attempted voluntary manslaughter, the state must prove the following elements beyond a reasonable doubt. Jason S. Rodriguez intentionally committed an act which would have resulted in the death of Gregory Hornbeck and or Guy Luginbill and or Edward Serrano and or Keandra Harrison and or Pharaoh Hickson, except that someone prevented Jason S. Rodriguez from killing Gregory Hornbeck and or Guy Luginbill and or Edward Serrano and or Keandra Harrison and or Pharaoh Hickson, or he failed to do so. However, the defendant cannot be guilty of attempted voluntary manslaughter by committing a merely negligent act, or if the attempted killing was either excusable or justifiable, as I have previously explained those terms. I will now define negligence for you. Each of us has a duty to act reasonable and use ordinary care towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. It is not an attempt to commit manslaughter if the defendant abandoned the attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose. In order to convict of attempted voluntary manslaughter, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide. To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. 1. Jason S. Rodriguez intentionally touched or struck Gregory Hornbeck and or Guy Luginbill and or Edward Serrano and or Keandra Harrison and or Pharaoh Hickson against his or her will. 2. Jason S. Rodriguez, in committing the battery, used a deadly weapon. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. If you find that Jason S. Rodriguez committed murder or attempted murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, or used, or threatened to use, or attempt to use a firearm, you should find him guilty of murder or attempted murder with a firearm or any other lesser included offense. A firearm is legally defined as any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. If you find that the defendant committed murder or attempted murder or any lesser included offense, but you are not convinced beyond a reasonable doubt that he personally carried or displayed or used or threatened to use or attempt to use a firearm, then you should find him guilty only of murder or attempted murder or any lesser included offense. An issue in this case is whether Jason S. Rodriguez was insane when the crime allegedly was committed. There are two ways in which a person can be found insane. The first is known as insanity, and the second is known as insanity hallucinations. You are only to consider insanity hallucinations if you find the defendant sane under the insanity instruction below. A person is considered to be insane when, 1, he had a mental infirmity, disease, or defect. 2, because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. A defendant who believed that what he was doing was morally right is not insane if the defendant knew that what he was doing violated societal standards or was against the law. All persons are presumed to be sane. The defendant has the burden of proving the defense of insanity by clear and convincing evidence. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief without hesitation about the matter in issue. In determining the issue of insanity, you may consider the testimony of experts and non-expert witnesses. The question you must answer is not whether the defendant is insane today or has ever been insane, but whether instead the defendant was insane at the time the crime allegedly was committed. Unrestrained passion or ungovernable temper is not insanity, even though the normal judgment of the person be overcome by passion or temper. If you find that Jason S. Rodriguez committed the crime, but you find by clear and convincing evidence that the defendant was insane at the time of the offense, then you should find him not guilty by reason of insanity. If your verdict is that the defendant is not guilty by reason of insanity, that does not necessarily mean he will be released from custody. I must conduct further proceedings to determine if the defendant should be committed to a mental hospital or given other outpatient treatment or release. Jason S. Rodriguez currently is being administered psychotropic medications under medical supervision for a mental or emotional condition. Psychotropic medication is a drug or compound affecting the mind or behavior, intelligence functions, perceptions, mood, or emotions, and includes antipsychotic, antidepressant, anti-manic, and anti-anxiety drugs. Insanity hallucinations. An issue in this case is whether Jason S. Rodriguez was insane when the crime allegedly was committed. A person is considered to be insane when 1. The person has a mental infirmity, disease, or defect. 2. Because of this condition, the person had hallucinations or delusions, which caused the person to honestly believe to be facts, things which are not true or real. The guilt or innocence of a person suffering from such hallucinations or delusions is to be determined just as though the hallucinations or delusions were actual facts. If the act of the person would have been lawful had the hallucinations or delusions have been actual facts, the person is not guilty of the crime. A defendant who believed that what he was doing was morally right is not insane if the defendant knew that what he was doing violated societal standards or was against the law. All persons are presumed to be sane. The defendant has the burden of proving the defense of insanity by clear and convincing evidence. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief without hesitation that about the matter in issue. In determining the issue of insanity, you may consider the testimony of experts and non-expert witnesses. The question you must answer is not whether the defendant is insane today or has ever been insane, but whether instead the defendant was insane at the time the crime allegedly was committed. Unrestrained passion or ungovernable temper is not insanity, even though the normal judgment of the person be overcome by passion or temper. If you find that Jason S. Rodriguez committed the crime, but you find by clear and convincing evidence that the defendant was insane at the time of the offense, then you should find him not guilty by reason of insanity. If your verdict is that the defendant is not guilty by reason of insanity, that does not necessarily mean he will be released from custody. I must conduct further proceedings to determine if the defendant should be committed to a mental hospital or given other outpatient treatment or release. Jason S. Rodriguez currently is being administered psychotropic medications under medical supervision for mental or emotional condition. Psychotropic medication is a drug or compound affecting the mind or behavior, intelligent functions, perception, mood, or emotions, and include antipsychotic, antidepressant, anti-manic, and anti-anxiety drugs. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you ought to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and the quality of the evidence presented. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is only reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in this case. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are dependent upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of witnesses and have seen in the forms of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. Remember, your lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not guilty in accord with the law. It is the judge's job to determine the proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding the verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that makes you think I prefer one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify, or not guilty by reason of insanity. If you find the defendant committed the crime, but you find by clear and convincing evidence that the defendant was insane when the crime was committed, then you should find him not guilty by reason of insanity. If you return a verdict of guilty, it should be for the highest offense which has been proved beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. Only one verdict may be returned as to each crime charged. The verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you. Verdict as to count 1, murder in the first degree. We, the jury, find the defendant guilty of murder in the first degree with a firearm as charged in the indictment. We, the jury, find the defendant guilty of the less included offense of second-degree murder with a firearm. We, the jury, find the defendant guilty of the less included offense of manslaughter with a firearm. We, the jury, find the defendant not guilty by reason of insanity. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank day of November. When you have arrived at a verdict, your foreperson will date and sign the verdict form. Verdict as to count 2. We, the jury, find the defendant not guilty of attempted first-degree murder with a firearm as charged in the indictment. We, the jury, find the defendant guilty of the lesser included offense of attempted second-degree murder with a firearm. We, the jury, find the defendant guilty of the lesser included offense of attempted manslaughter with a firearm. We, the jury, find the defendant guilty of the lesser included offense of aggravated battery. We, the jury, find the defendant not guilty by reason of insanity. We, the jury, find the defendant not guilty. Verdict as to counts 3, 4, 5, and 6 all reflect the same thing with the name of the victim for each count. When you have arrived at a verdict, your foreperson will check the space adjacent to the statement that reflects your verdict. There are also some special verdict forms for each count. Special verdict form as to count 1. We, the jury, find the defendant did actually possess or carry a firearm during the commission of the crime. We, the jury, find the defendant did not actually possess or carry a firearm during the commission of the crime. We, the jury, find the defendant did discharge a firearm during the course of the commission of the crime. We, the jury, find the defendant did not discharge a firearm during the commission of the crime. We, the jury, find the defendant did cause the death of Otis Beckforth by the discharge of a firearm during the commission of the crime. We, the jury, find the defendant did not cause the death of Otis Beckforth by the discharge of a firearm during the commission of the crime. And the special verdict forms as to counts 1 and counts Rev 2 through 6. We, the jury, find the defendant did not possess or carry a firearm during the commission of the crime. We, the jury, find that the defendant did not actually possess or carry a firearm during the commission of the crime. We, the jury, find the defendant did discharge a firearm during the commission of the crime. We, the jury, find the defendant did not discharge a firearm during the commission of the crime. We, the jury, find that the defendant did cause bodily harm to the victim in each particular count, which is specified on the verdict form, by the discharge of a firearm during the commission of a crime. And we, the jury, find the defendant did not cause bodily harm to the named victim by the discharge of a firearm during the commission of a crime. Again, when you have arrived at a decision, your foreperson will check the space adjacent to each statement and date and sign the verdict form. A separate crime is charged in each count of the indictment, and while they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. The finding of guilty or not guilty by reason of insanity as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During your deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communications, such as blogs, Twitter, email, text messages, or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given you in this case, you must tell me by giving a note to the court deputy. If you need to communicate with me, send me a note through the court deputy, signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any question if I can in writing or orally here in open court. Your verdict finding the defendant either guilty or not guilty by reason of insanity must be unanimous. The verdict must be the verdict of each juror as well as the jury as a whole. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin your deliberations. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have agreed to a constitution and to live by the law. No juror has the right to violate rules we all share. May the attorneys approach the bench. It appears as though juror number 1 and juror number 259, that the other 12 members of the jury are alive and well. So I'm going to ask that juror number 1 and juror number 259 remain in your seat. The rest of the members of the jury, you are now excused to begin your deliberations. Has their lunch. I think maybe juror number 1 and 259 may have some things in there. You're to bring them out to them. Okay, members of the jury, you may not be excused to begin your deliberations.
All rise, jury exiting.
Huh? What? Just a second.
Everybody come back, please, for a second. Come back for a second.
Let's double check. I had juror number 1 and juror number 259. Is that correct? Yeah. may be seated. On behalf of the citizens of the Ninth Judicial Circuit, more particularly the citizens of Orange County, Florida, I would like to thank you for your service as jurors. A strange thing happens at this courthouse 50 weeks out of a 52-week year. There are literally hundreds upon hundreds of cases which are set in this courthouse and in the courthouses in our circuit. I say this, without people like you who are willing to take their civic responsibility seriously, then the constitutional principles which our country was founded on, the right to a trial by jury, could not exist. It is because of citizens like yourself that our civil and criminal justice system works, because the litigants and attorneys know that if they cannot settle cases, that these cases will be heard and that jurors, just like you, will take the law and apply the law to the facts and make a decision. This is what separates our country from any other country, I think, in the world. If you go back to common law England, one of the complaints about jurors during that time, that they was selected by the king in secret and selected with one purpose alone, to make sure that a certain outcome came. And that was one of the principles which this great nation was founded upon. I apologize for any inconveniences that you may have suffered. We've tried to move this case along as quickly as possible, consistent with the constitutional principles that were enacted by our forefathers. The question is often asked, well, why do we need alternate jurors? I can assure you during the many years that I've done this, that there has always been a need to have alternates. I've had to replace sitting members of juries at least on 4 occasions. If we don't have alternates and something happens to one of the jurors, then unfortunately all the work would be for naught. Your lunches will be served to you separate from the rest of the members of the jury, since they can't talk with you now. You are free to leave. You are also free to discuss anything with anybody that you would care to discuss. That will be left up to you. Remember, a request may come from those who are just simply curious, but it will be up to you to decide whether or not you want to talk with them. You are free to leave, or you're also free to remain with us until the outcome of this case. If you wish to leave and go home, if you would leave your name and a contact number, then the clerk will call you and let you know the outcome of this case. Again, thank you very much. You're hereby discharged with my sincere thanks and appreciation. All rise. All right, you may be seated. Will the attorneys come up and inspect the evidence before it goes back? I take it with the DVDs, they're going to have to come back out here to look at them if they want to look at them. Is that correct or not correct?
I don't know what equipment is in that.
There's no equipment back there. Do you want to send the equipment back there?
I have no objection to that. The only thing that we would need to pull out that is actually in evidence is the CD of his statement, because I stopped it at a certain point in conjunction with an objection. So
That would have to be shown in court.
stop it again at the same spot.
Okay, please go over the evidence, and I will, while y'all are doing that, I will run up and get copies of the jury instructions that I had printed out for them to take back. Please also inspect a copy of the indictment to make sure that it is okay with everyone. Let me run up and get the instructions while y'all go through the evidence.